Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a really good book again from Sweet Maxwell and THOMSON REUTERS. This book is an important one in what we call company law, corporate governance, whatever you like, but it's basically about companies, and it's schemes of arrangement in corporate restructuring. And of course it's an important area because any company will possibly have to look at the way it's running its business, and will obviously with external problems have possible need for review of the way in which the company is structured, especially if debt becomes a major issue. Now, this is the second edition of the book from Christian Pilkington, and as I say, it's come to us from Sweet Maxwell. Now, Elizabeth and I have written a book review of this work, which will be on the web and in the journals, and Elizabeth has written most of this particular review, and she's given it the title, A Definitive Text on Corporate Restructuring, and now in a new edition from Sweet Maxwell. I'll talk about the book in a minute. Let's have a look at it first of all. It's a blue cover, hardback. It's not a big book, actually. It's quite a small one. There is the spine, and then there's actually nothing on the back. Now, you've got the standard structure for a Sweet Maxwell text. There's the index right at the back, and of course it's quite a, to be expected, quite a reasonably detailed index, and it's based on their legal taxonomy. That means to say it's by paragraph numbering, and it's very much in the style of the Sweet Maxwell decision on what titles to give particular substantive law tags, if you like. So you should be able to find stuff. In other words, it's a standardised procedure which Sweet Maxwell have, just to make that clear for those who are not familiar. You can see there's a useful annex at the back, various other things. You've got some flow charts as well, which are quite helpful. I think there are a total of 9 annexes. There's one of the flow charts, a total of 9 annexes. It's not a big book. It runs to about 250 pages, so it's not a big book at all. Now, Christian Pilkington, who is the author, he is the partner and head of the EMEA Financial Restructuring and Insolvency Group, White & Case LLP. So that's who he is. Now, there's the information, some blurb about the book, and then acknowledgements. A lot of acknowledgements there. A lot of help he's been given. Then you've got the basic contents, and you see the various structure, history of the schemes when they first started, and how they basically work, running all the way through. Tax considerations, very helpful. And as I say, the total number of chapters are 13. It finishes with schemes involving distributions of securities. Then you've got 9 annexes which are there. Then there's a preface. Always read the preface because that gives you some idea of what this book's about. The English law scheme of arrangement, or scheme, is now an established tool of choice for those engaged in complex financial restructurings, in particular where a consensual solution between all of the company's creditors is not possible. That, of course, is the basis about why we don't really want to intervene as lawyers. The law is as stated on the 31st of May 2017. Then you've got various information pieces there to start everything off. Then you have some useful tables of cases, and then after that there's a little bit of statute law, obviously mainly the insolvency legislation, and of course a little bit about Companies Act. Then there's some SI, statutory instruments. Then you have the body copy. You see how it's structured, paragraph numbering, and then there's a little bit of footnoting, but very little, thankfully. I say that, there's a little bit more there, but generally speaking it's a book which you can run through, and it flows well. I say that because some books do tend to, I have to say, go a bit over the top with the footnotes. So what do we say? Well, commercial lawyers will welcome this recent publication from Sweet Maxwell, a new second edition of what's a highly regarded text on corporate restructuring, a process often seen as one of the most sensible solutions available to those dealing with the problems of corporate debt. Now, we've been quite lucky in the last 10 years with very low inflation rates, very low interest rates, and we haven't seen huge numbers of businesses go to the wall. But there have been a large number. I've been involved in quite a few pieces of litigation in this area, so I can see the value, if at all possible, never go to law, because if you can get a solution another way, that is certainly the best way of doing it. Now, commonly called the scheme, as I've said, which refers to an English law scheme of arrangement, corporate restructuring is, in the words of the author Christian Pilkington, an established tool of choice for those engaged in complex financial restructuring. And that is the theme running through the book, especially in situations where creditors are cutting up rough, raising the roof, or being awkward, argumentative, and impossible, which of course is understandable because they want the money, because they've probably got to pay people as well. Therefore, unable to reach a consensus as to the way forward, you have this type of scheme, and that's clearly set out. And as I say, the history of it is given too, because it's a relatively new type of approach. It seems that since the economic downturn, which means the disastrous economic crash of 2008, which is basically 10 years ago now, corporate restructuring has been more commonly used, said the author, not only for UK-based corporate entities, but also for those from overseas companies, provided they have the required sufficient connection with England or Wales. And I say that because obviously the view post-Brexit of Britain is that we still want certainly London and England and Wales to be the centre of legal decision making, bearing in mind we created the common law effectively and given it to a very large number of countries. But the point to be made is that it is that connection, and obviously it's something we want to keep after we leave the European Union. Now, as the author further explains, such schemes have come to be generally regarded as more user-friendly and more efficient than local law alternatives. And there's apparently a statistic which shows that in 2016, over 75% of scheme applicants were foreign companies which met the usual requirements. That's an interesting statistic, I think, to see the effect of the way English law operates, because it is fairness, and I have to say it's the best system in the world. Now, but of course there are other complications that arise, primarily increased and more rigorous security by the courts on supporting evidence, for example, and other issues such as the identity of creditors is certainly something which has to be taken into account, because obviously you can't have a complete free-for-all, you can see that. Now, the biggest complication of all, of course, is Brexit. And it puts into question the recognition of the schemes of arrangements by EU member states. And hitherto such schemes are automatically recognised and enforced. I just hope we can save that one. It would seem sensible to keep it in place, I have to say that. But that's a matter for the politicians. These and a host of other related issues are discussed in detail throughout the new edition, which includes leading cases in this area which have emerged since the previous edition came out in 2013. And then there's a new chapter on different areas of law relating to schemes of arrangement, including those pertaining to listed companies, to tax, capital markets, bond restructuring, and more. And of course, you've got what you have here. Remember, this is not a book for beginners, but it's relatively easy to read, so it's not too much full of legal gobbledygook. It therefore means that you've got a reasonable approach adopted by the author, which makes it readable. Now, there is a new feature too in the form of an annex, that's in addition to the 8 other annexes, which provides in tabular form, and I showed you that is right at the back, a comparison of schemes across 7 other jurisdictions. One is reminded here that in terms of procedure, a scheme of arrangement in the UK equates to Chapter 11 of the Bankruptcy Code in the United States of America. And at the front of the book, again, there's one of these tabular things at the front. It's a tabular summary containing a 6-page listing of big corporates, many of them overseas, which in recent years have gone pre or post restructuring debt. They've actually undergone it specifically. I'll show you those again in a minute when we look at the book for a final time. Let me conclude by saying this book is written with both clarity, authority and style. In addition, it's navigable, it's information rich and easy to use as a work of reference. on what is often a vexed and complicated subject, because when you get to the point where you may have to start looking at this, things really are not working out the way they should do, and you can understand people are naturally getting very anxious. Now, it should be a must-have purchase, we think, for every practitioner involved in this area of corporate law, and I'm sure they have it. As I say, the law is stated as the 31st of May 2017. Let me show you these tables because I think they're quite important. This is the book again. The tables are right at the front. Before you get anywhere else, it starts here, and it's actually the only thing it's a bit difficult, it doesn't actually have a title on it, which is a bit unfortunate. But however, those are the tables at the front showing the large companies, listing them by name. You can see them there, and again, it's a whole range of companies there. Then if we go to the back, this is the innovation for this edition. It's Appendix 9, the Scheme of Arrangements, International Comparisons. And then you've got quite a useful list of comparisons there. You can see how the structure is actually working without going too much through it. And just to remind you again, you've got paragraph numbering at the sides, you've got footnoting, and the index at the back is a legal taxonomy, which is by referencing. Well, thank you, Christian, and thank you very much to all concerned for another excellent title from Sweet Maxwell. You make our lives a lot easier by producing these works, and we thank you all very much indeed. Bye-bye.